Good evening, everybody. I know you are enjoying great conversations at your tables, but we would like to go ahead and begin, and so I want to just take a moment to welcome all of you. It's so good as your pastor to see you all here and taking this time to be able to look after your family and the kingdom of God as we talk about the blessings that we have received and what we might be able to do for the future and to have wisdom in that process. We're excited, Dennis and I. Dennis is our treasurer. I think Dennis, wave in case folks don't know who you are. Dennis is an elder and our treasurer, and Dennis and I were chatting about this kind of an event, the need to provide some training, some education for us around the idea of estate planning and plan giving for the future. And I contacted our friends at Converge because I shared with the folks at church this morning, I think most of you were there, that we're a Converge congregation. We plant churches through Converge. And we have an expression in Converge that we're better together. And we were delighted to find out that within Converge, in one of the districts, the North Central District, which is Minnesota and Iowa, that they have been doing just the kind of thing that we were looking for. And in conversation with Barb, who is part of the National Converge office living in the Chicagoland area, Barb began to make some connections for us. And we are now the first church outside of the North Central area that is presenting the kind of seminar that we're having this evening. And to help us with that are two guys that have done it in many, many congregations. I think I heard Jeff this morning, over 100 congregations in the North Central region. And we are the first outside of that area. And so I'm looking forward to what Andrew and what Jeff have to say this evening, and I would like it if you would give them a warm North Sound Church welcome.
Well, thank you, Pastor Barry. My name is Andrew Dibble. I'm an attorney out of Minnesota. My law firm is Generations Law Firm, and we have been partnering with Converge for a number of years, bringing educational content around the area of estate planning. Super fun topic, contemplating our own mortality, but it's necessary to make sure that your family doesn't inherit a mess when you pass. Now, thankfully, we have been able to partner with Resnova Law. Susan is in the back from Resnova. She's an attorney that's licensed in Washington. So all the content we're going to give you tonight is reflective of Washington law. And again, this is just meant for educational purposes only. It's step one in a multi-step process of going to maybe not having anything done right now or yet to getting something done. But thank you for having us. We're really excited to be here.
Thank you. I'm Jeff. I'm a certified estate planner, so that means I know enough about this stuff to be dangerous. But he's the doctor and I'm the nurse, so that's how we work together with our lawyers here at Generations Law Firm. So we're happy to be out here, and I know this says Minnesota up here, as Pastor Barry pointed out, but we didn't have time to edit some of this. So this content is going to be for all of you tonight here in Washington, and with Susan's help in the back. If we get any questions above our pay grade, we've got someone back there that can help. So we're going to get into this. As Pastor said, we've done this workshop in about 122 churches throughout the Converge network. And tonight, this is our pilot program to bring it outside, and Converge as a whole, nationwide, is looking to bring this education to more churches because of how it blesses the families and even indirectly how it blesses your church. Because we're going to talk a little bit later on how some of you might have a heart to give and might want to maybe support your ministry or kingdom purposes in the future. And all of that happens from a little class called Who Will Inherit the Mess that we've been doing our team's been doing it for about 15 years, but we've been hooked up with Converge about 4 years now, and through this grant that the Lilly Foundation has provided, and John Wicklund is sitting in the back, he could tell you more about that. That is underwriting all of the costs so we can just be here tonight and just relax and receive. So this is a give from your church tonight. This is not an ask. And thank Pastor and Dennis and folks like that on your board for recognizing this might be beneficial to all of you. So without further ado, we're going to get into it unless there's anything else. But so that's the class. So we don't want anyone to inherit a mess, but we're going to talk about how we can avoid that. And my guess is a lot of you have some of these documents in place. I'm going to get my clicker going here. And now we tested it earlier, and it was, there we go. So this class, this little workshop, is for anyone that maybe doesn't have a plan, because even at this stage of our lives, you know that most Americans don't have one. I don't know what stats you've heard. I've heard about 60% of Americans don't have any documents in place. Those that do, they may not be done correctly, or the assets might be in misalignment. So maybe you have an old plan. Maybe you do have something done, but it might be older, it might need to be updated. Maybe life has thrown you a couple curveballs. Maybe life has changed, and you might need to update something. So these are all reasons why this might be a good class for all of you. And for those that have adult children or grandchildren, even for minors, younger parents that have kids, there's things that they could still pick up, and some of these documents would be applicable to them as well. So you'll see that this covers many generations, not just an older guy like me. So let's get through the housekeeping here a little bit real quick. So the handouts you've got, as we talked about, you can take all that home. There is one we call in here a yellow card. And the yellow card is totally up to you if you would like to fill this out. And why would we do that? Well, it's for anyone that might want to take this education a step further after tonight. It's complimentary to you. The grant from Eli Lilly Foundation underwrites even that follow-up meeting. It's a no-cost consultation. It can be over the phone. It can be virtual. It can be in person if you happen to be closer to Susan's firm there. She's got several different locations. But this is for you if you wanted to learn a little bit more after tonight. And just be available, or be aware that this is available to you. And I've got a little white tray in the back of the room that you could drop this in if you would so choose. That's the yellow card. We also have a bio in there about Susan's firm, so you can learn a little bit about her. And of all the firms out here, there aren't too many that were understanding this whole concept. And maybe, I don't know if you want to speak to more of that, but we just ended up working with Resnova, and they're going to be our trusted, competent legal source here in Washington, because, Andrew, you're not licensed in Wisconsin, and neither am I.
Not licensed in Wisconsin, and also not licensed in Washington.
So there you go. That's
what
why
we're doing is education. If you want to follow up, that's where Susan comes in. She can help with specifics. A lot of times we meet with people. We offer questions during the presentation, but a lot of times some of your questions might be a little personal, maybe a little detailed, and that's really what this second step is for, to really get into the nuts and bolts and weeds of your specific situation in maybe a more private environment that doesn't get us off track during a presentation like this.
So that's that. And then there's another sheet in there a little bit about how to prevent the mess. Normally in Minnesota, we include some other documents in our folders. We took some of them out because we just want to make sure it's all specific to Washington. But the one about preventing a mess, it's a fun little checklist you can take yourself through and give yourself a passing or a failing grade. And if you're failing, then maybe give Susan a call and we can fix that. So anyways, that's the handout. So the mess, there's a lot of reasons for the mess, isn't there? The mess can be described in a lot of different ways. We're just going to show you a couple different adjectives that you might resonate with. But we see part of the mess being uncertainty when someone passes away. And I don't know where Barry's sitting right now, but he was mentioning this morning in the service, your own church here just lost a couple members recently. And I don't know anything about that family or anything, but my mind immediately goes to this topic. Will the people they left behind, is there certainty on what's going to happen? Do they understand the documents that might have been left behind? Hopefully there are documents. Hopefully there's been communication. But uncertainty is a tough one for families when we're gone, because they can't ask us anymore, and we want to try to make sure we're not leaving that behind. Uncertainty and unawareness, or not finding the documents, or disagreements, all that can cause a lot of friction. You're dealing with a family that's got a lot of children up in Minnesota with friction right now. I'm dealing with one in Iowa where there's friction. It was 10 days from the father when he passed, and it was a second marriage. And his wife, they were separated for a year, but still legally married. So now she's being pulled back into the estate situation because they're still legally married. And guess who's already calling the stepmom trying to get a hold of dad's money, and they're upset about things. It was his biological children. And now they're trying to call their stepmom, and she can't do anything. They won't believe her. They think she's hiding the money, and it just... Yeah. That's friction. There's plenty of stories there we could share. Another example of a mess is just the delay that comes into play. What do you think's the average in Minnesota now? What do you think's the average probate?
For a probate, in Minnesota at least, it's a minimum of 4 months because there's publication requirements. You have to file things with the court. But often it's way, way more than that, closer to a year, maybe a year and a half to get from point A to a fully closed probate. It just takes a long time. And it costs money. Who here likes paying lawyers?
Yeah, anyone? All right, well.
Got a couple retired counsels here, right?
That's right.
That's right.
That's right. That's okay.
I got some support. Yeah.
Well, I joke. I don't know. Susan, don't get mad at me, and Andrew, don't get mad at me. But see, as a non-lawyer, I can share things a little bit differently. I've always explained probate as nothing more than the legal industry's retirement program, because we're paying money into this system that is mainly going for courts and legal fees and lawyers. And call me crazy, but I think that money should be going to your loved ones, your children, your charities, and your churches. But so when there's a delay in the money flowing, that can cause friction and other things. So we don't want there to be a delay. And but sometimes there's these court-sponsored delays because of probate and the way it works. We're going to talk a little bit about probate because it's very similar in Washington as is in Minnesota, and where you just want to try to avoid it. And then probate is not really a nonprofit experience for the people that go through it. I don't know if any of you would be willing to raise your hand, but I went through probate after my parents passed away in Minnesota back in 2013. My dad went first, and then my mom in 2013. And they kept telling us 4 kids, I'm one of 4 kids, Jeff, Greg, Teresa, Sandra, don't worry, we got everything taken care of. We work with Ken, who we like and trust. So Ken was the family lawyer. Well, I don't know if it was Ken's fault or mom and dad's or all 3, but things weren't in order. And it cost us about $3,700 to probate 2 parcels of land or just west of the Twin Cities, and it took 13 months. So we dealt with both a delay we didn't see coming and a cost. Now, thankfully, us 4 kids got along. Thank you, Mom and Dad, for raising us well. And there was no fighting or anything like that. But there very easily could have been. But we were more upset. You know what we were more upset about was not the $3,700, whatever it was. It was the 13 months that we couldn't do anything because it all was caught in that court process. So we're just wanting to avoid that. This is just some, there's other things we could put up here to describe the mess, but this is a good start. So let's keep going. There's a lot of root causes. Why don't you talk about the plans, because they're so important.
So the other side of our firm is probate. So my firm does trusts and estates and wills and things like that on the front end, but we also handle probate for people on the back end if they don't have docs or need to wrap things up through the court. And what we've noticed is very, very consistently, 9 times out of 10, there are some key things that lead to messes at the end of life. Mainly not having a plan. So if people don't have any documents, if they didn't set up a will, if they didn't set up a trust, if they don't have transfer on death deeds on their property, if for whatever reason they didn't put beneficiary designation forms on their financial accounts, that leads to a mess. You're going to be in probate. People aren't going to be clear about who's in charge or who's supposed to do what when people pass. And we get a lot of clients that come in and say, okay, Mom just passed away, now what do? There's no documents, and then it costs a lot of money and takes a lot of time. So the number 1 cause of the mess is not having any documents in place and having no plan. Second would be an outdated plan. So a lot of times people have a will done 30 years ago and they think they're set, but those things need to be updated. It's kind of a living document. Things change in your life, things change in the world. Your assets might change, and depending on how your will was drafted, it might not be relevant anymore, depending on what you've got going on in your life. The person you've nominated as your personal representative might be deceased. And so that can cause some problems too. So we always recommend people update their wills or trusts or beneficiary designation forms to reflect what's current and going on in their lives in the present. And a lot of times people don't do that. They think it's one and done, and that causes problems later on. Lack of communication, and this is twofold. Communicating with your loved ones about what your intentions are is important. You don't need to tell your children or your beneficiaries how much they're getting or when or why, but it's important to communicate with the people that you're naming in fiduciary capacities, like a trustee or a power of attorney or a personal representative or even a health agent. Letting those people know that you've nominated them in these documents is important so that they have that understanding and expectation when you pass. It's not easy for somebody that's stepping into a trustee position to find out about that a few days after you pass away. It can be a complicated process to go through, and letting them know and kind of prepare for that ahead of time really evens things out for them when the time comes.
Well, can I add to that?
Yeah.
Our generation in the room here tonight, I would say most of us are probably in our third or fourth quarter of our lives, as I would describe it. The older the generation, the less likely they like talking about any of this to their children, to their loved ones. They're private. Sometimes that's that generation we grew up in. They don't like talking about money. They don't like talking about any of this. Some parents think the kids might be looking at them like a 12-point buck, waiting for the day, and how much am I getting? And we don't. So there's a lot of reasons why this can be a challenging topic to discuss. But folks, if you're gone, or if you get a bump on the head and you're still here, but you can't speak or act on your behalf, everything's coming to a screeching halt. Your loved ones can't do anything without, and they don't know what to do, and they can't talk to you, and all we needed was a little conversation ahead of time. So we're advocates of some sort of family discussion. As Andrew said, you don't have to share all the zeros in the bank, but even those stubborn old men, sometimes we gotta talk about this a little bit, because it's hard on the children if you've never discussed it, if they don't have any idea where the plan is, what it says, and that kind of thing.
Yeah. The other important element of communication is communication amongst your advisors. So you may have a lawyer, you may have a financial advisor or a wealth manager, you may have a tax accountant or a CPA or something like that. It's important for those people to talk about your plan too, or at least be open to having that conversation with each other, because that can lead to some problems as well. Does everybody know what a beneficiary designation form is on a financial account? Like an IRA or a bank or anything like that?
Yeah, hopefully. Did you know that some of your assets don't come with a beneficiary and you have to add it? And if you have an advisor that doesn't bring it up, or if a banker that never approaches that subject, now we might forget about that. So sometimes we have to add it. Not everything comes with a beneficiary.
And what you'll learn through the workshop tonight is that beneficiary designation form trumps your will, trumps your trust. And so if there's a misalignment on what your beneficiary designation form says and what your will or your trust might say, that can lead to some friction and some problems later on.
Yeah.
Regardless of what your will says, where certain monies go to, your beneficiary designation form is going to shoot that money to whatever person you've named in that form.
I would argue that when there's messes and there's the need to hire Susan or Andrew to probate the estate because it wasn't done quite right, it's likely not what the lawyer did. It's what the lawyer didn't do. It's what the law firm or the legal industry cannot address, and that's aligning your assets with the estate plan. But to align these things, we need people like Wesley. I was talking to Wesley earlier, financial person. We need bankers. We need life insurance. We need, all these other people helping us align and update the beneficiaries or the ownership or the transfer instructions. And those people don't know much about the estate planning side of it because they're not the legal industry. So you get caught in this Bermuda Triangle between legal, finance, and tax. And that's where the problems typically lurk. So misalignment of the assets is a huge issue in your estate plan. We're going to talk more about that tonight as we keep rolling. So let's talk a little bit about a will, because I bet there's a lot of wills in the room. And there's things a will does, and folks, there's things a will doesn't do. And wills are pretty similar to how they work here in Washington versus Minnesota. So let's go down these, and if you want to jump in anytime, feel free. So let's go. I bet a lot of people say, well, I have a will, so I'm good. And by the way, if you have a question, please ask. We don't have to wait. We don't have to wait till the end. If it's right on the tip of your tongue, it might benefit everyone. So people think I have a will, so I'm good. Well, a will alone does not avoid probate. Not the will in and of itself. The will is a court document. A will is a set of instructions on how you want things to be distributed when you're gone. And a probate court and a judge you've never met or the kids have never associated with now gets involved, and sometimes we carry out your wishes. And then it's a matter of, well, what did Harry or Sally say in their will? And then we got to look at, well, what assets did they leave behind? So there's more to the will and avoiding probate than just signing a document. It doesn't mean a will is bad. It doesn't mean the lawyer did anything wrong or you did anything wrong, but we have to learn what that will does and what it doesn't do. So we don't want you going home tonight and thinking, I'm good because I got my will done. You know, every movie I've ever watched, there's always a will at the end of the movie, and, you know, Johnny, you're getting this, and as if it's that smooth and that easy, and it's usually not that easy. So we hear this a lot. My estate is so small, I don't need a plan. Jeff, Andrew, I don't have much. You know, it's just, I don't need to do anything, do I? Well, you should probably do something. Everyone is considered to leave an estate behind. And if you don't have an estate plan, guess what? The state of Washington has one for you. All right? And it may not be the one you would have chosen. It may not distribute assets the way you would have done it. They may not appoint the personal representative you would have chosen. But now we didn't do that because we didn't think we needed to. But everyone has an estate. Susan can talk to you more about this in the reviews because we got to be careful. Anything over $100,000, if you did not have a beneficiary on it, or any value of real estate, is going to have to go through the formal probate process to get settled, even though you have a will. Again, the will is a set of instructions. It doesn't convey ownership of real estate. Did you know that? So you can't just get that will drafted and think, I'm done with my cabin or my home or my Airbnb down the street. My spouse, kids can handle things, so they'll figure it out, they'll be fine. Well, no one can really do anything without the proper documents, without the proper setup, without the proper authorization. So these documents give that to them. And in a minute, we're going to talk about the types of documents we should have. There's a couple that are called living documents, and a couple that are called death documents or testamentary. So we're going to get into the 4 of those. How am I doing so far?
Doing great.
See, he's the lawyer. I got to make sure anything. I'm just I'm the nurse. He's the doctor. I got to make sure.
I charge by the word, so Jeff does most of the talking.
Yeah. All right. So Susan, so far so good. Hopefully in the back. All right. All right. People sometimes will say, hey, an estate plan is one and done. Thank goodness we got that done, honey, with the lawyer. Let's go to dinner and celebrate. We signed and notarized our document. Well, life changes. Plans do need updating. Life might throw you some curveballs. You might need to change your distribution plan. You might need to reappoint someone different as that general term would be executor, but what we really mean is a will. Now they're called a personal representative, and with the trust they're called a successor trustee. So sometimes life changes and we need to update it, so we got to keep our finger on the pulse of that. Anyways, I'm going to guard myself from going down a spur trail. Probate's not that bad. We hear that all the time. Well, it can be. Me and my 3 siblings survived, but it was a goat rodeo for 13 months, just trying to figure things out. And guess who we hired to take us through the probate process? Ken, who was very likable and trustworthy, by the way, but he did not set up my parents' property correctly. They did, Susan, they had a transfer and death deed for 1 parcel of land, but my parents had 3 parcels of land, and they were all adjacent, right next to each other, and Ken only put the homestead, the first one, on the transfer deed. So us 4 kids got that one right away, but we had to probate the other 2. Took 13 months. So we were not looking to turn around and go back on that probate ride at Valley Fair. Again, Valley Fair is an amusement park in Minnesota. So anyways, it can be. The thing about probate, it's avoidable. So we want you to realize it's all avoidable. So these are just a couple myths, and let's keep rolling here. All right. Why don't you take these to reality?
Has anybody gone through a probate for a parent or loved one?
Okay. How long did yours last? I'm just curious.
About a year.
Anyone else?
Anybody else?
Well, how?
Yeah.
It was about 6 months.
Okay, that ain't bad. 6 months, not bad.
27 months.
Okay, well, there you
That
go,
was yours,
Wesley.
27 months?
I had a lady, I didn't even tell you, in Minnesota. I was doing a class, and I said, we were asking this. She said, we're still in it, and it's been, I kid you not, it's been 6 years, because it was in another state, a lot of businesses, real estate, nothing was set up.
Right. Probate's not the end of the world.
Right.
It's just a court process. It takes time, it costs money, but it's not the end of the world, especially if people aren't fighting. It can be bad, though. Like I said, we do probates on the other side of the business, and some of them go 6 months, some of them go a year. But some of them take a long time and are expensive. If there's any kind of contention amongst the kids, that can cause delays and excess costs and things like that. Jeff alluded to one that I'm dealing with right now where there's 10 children, There were no documents. And there's a very expensive guitar collection.
Oh, yeah.
And the kids are all fighting over it. So there's basically 2 camps, 5 and 5, I think, or 6 and 4. And they couldn't decide who they wanted to have as their personal representative for the estate. And so guess who decided? The court did. And they picked a third party that person has to be paid to do it, and that's a lawyer. He's getting $300 an hour to be the PR of that estate.
Yeah, no will, right? There was no will?
No, yeah, he didn't have any documents.
And you said the guitars were worth like $500,000?
Yeah, it was a big guitar
Yeah,
collection.
so he's
Big
talking
guitar
about
collection.
personal property. We're just talking about guitars. But to that family, everyone wanted them. And
Yeah.
now we're fighting over personal property, not even the major stuff. I don't
Yeah.
even know what's going on with the major stuff. But
So probate isn't the end of the world, but it is totally avoidable. So a little bit of planning up front, a little bit of cost up front can basically reduce or eliminate the risk of having to deal with these issues later on. And the cost, delay, and acrimony that it can lead to. Not saying that's going to be your family, not saying it's going to be your situation. A lot of probates happen across the country every year, and everyone survives. But I bet if you ask most people, they would rather not go through that process if they don't have to. It's not super fun.
that's right. Well, and this is kind of what we're talking about. If we were in Minnesota, we'd have a kind of a big little scary chart that I hold up. But this is kind of the steps we go through, which is formal probate. So Susan, obviously anything over 100 grand, right? In Washington, we'd have to start at the top. And I know you can't really read this, but at the top, how we start the process, it says, reads your will. You have to submit the will to the probate court. Even if you got all the assets set up correctly, we still have to probate the will, the document. And if any assets do have to go through this formal process, who benefits from this? The court, Susan and Andrews of the world, not necessarily your family. So my younger sister Teresa kind of worked with Ken and navigated this. And then we didn't get anything till the very bottom box, the final discharge of the assets. Everyone else is getting paid first before the family. We couldn't sell anything. We couldn't do anything. We couldn't give anything to the church. If mom and dad wanted to do that, everything kind of gets locked. So that's just a visual of what formal probate is. Now, again, to be fair to wills are not a bad document, but as Andrew said, to avoid this, we have to set up all of the assets correctly. All of the assets have to have a pathway from A to B. B might be your children, right? B might be the church. B might be a combination of those things, but you have to coordinate and kind of orchestrate the transfer of these assets because your will is simply a set of instructions to a probate judge. Your will is not a beneficiary form, right? So, and if the will says one thing, and as you said, the beneficiary form says something else, when the day comes, which one's going to win? The beneficiary form is going to override even the will. That's how important they are. So we want to make sure we're in proper alignment with all the assets you might have left behind. So just know, messes are predictable and preventable, but we just have to talk about it. So that's why I'm glad we're here tonight. And Barry, thank you again for bringing our team in to share this with you. And you'll be another pioneer out here with this if it goes well, and we think it will. So let's talk a little bit about the documents that we do need to avoid the mess. Does that sound good? We'll get into the actual rubber where the rubber meets the road. And here they are. We're going to talk about the 2 living documents there on the left, a financial power of attorney and a medical health care directive. I bet most of you have these documents, but we are still going to dive a little deeper and talk about that. And then we're going to end up with wills and trusts. Because in my humble opinion, and I'm not even the lawyer, I don't think there's any 2 documents more misunderstood than wills and trusts. And part of it's our legal industry's failure to really slow down and educate and take you through and give you the pros and the cons, and rather than saying, oh, you don't need to do this, just do that. And we just want to learn. Okay, let's go. Financial power of attorney. You want me to take it?
Yeah.
I'm on a roll. All right, so I got one up here, just a standard Washington basic financial power of attorney. Susan, I might draft one that looks a little different. Sometimes you can download these if you're brave enough. But we do want you to be careful because this is a very powerful document. Why is it called a living document? It's only valid while you're on the right side of the grass, as I'll say, okay? So this is a very important document where you appoint someone. They're called your attorney in fact. I just say they're your financial helper. And you're giving them the authority to help you with your financial matters if you get a bump on the head and you cannot speak or act on your behalf. Now, so if you don't have this document, or if you have it and we don't know where it is, because we never communicated as a family, well then, what happens? Nothing, all right? Or I got to go down to the court and talk to some judge I've never met and try to get appointed as your attorney in fact, and we don't want to go through that process, costly, delays, and what if our loser brother Larry walks through the door and he wants to be your power of attorney and you were going to pick somebody else? As I joke, I don't have a loser brother Larry, but I joke about him. Because sometimes people get appointed by the courts, and it's so easy for us to do on our own. So now every person should have this document. Dad has his and mom has hers. All right, you're going to name each other even as a married couple, right? But what if mom and dad are in the same car accident coming home from church one morning? Well, now who can help dad because mom's in the hospital bed next to him? So we like to have an alternate, one or two. Susan does as well. We just don't want to stop at one because that doesn't give us a little bit of if-then scenarios down the road. They all need to be signed and notarized properly, okay? But it's very important, and they can just help you with banking, insurance, or getting new tabs on your car and selling a piece of real estate or whatever. Whatever you can't do, your attorney, in fact, has the authority to do it for you. So this document is really important. We think everyone in the room should have one that's relatively current, not 30 years old, because it might get rejected by an institution. In Minnesota, we've updated ours, Susan. I don't know if they've done that here in Washington, but we updated ours, when was it, 2013 or something like that? So every now and then the legislature will update it, and it's just nice to be relatively current because it's such a powerful document. And even as I close here, your adult children, anyone over the age of 18 should probably have this document because they have their own bank account, they have their own rights, it's their account, it's their house, and even you as a parent can no longer help them unless they give you that authority back. See how important this is?
There are some caveats with this.
Yep.
Once you grant somebody this authority, they can act even if you don't have a bump on the head. So if you are out of town or overseas or something, you can call and say, hey, I need you to take care of X, Y, Z, and they'll be able to do that. There's something called a springing power of attorney, which comes into effect if you're incapacitated, if and only if you're incapacitated. That's a springing power of attorney. So if you don't really have anyone that you want to appoint that has this power all the time, you can utilize one of those. Now, you do need evidence of incapacitation before that becomes effective, and that can cause some delay. So we generally recommend naming a trusted person to act in that capacity. Usually it's your spouse, and then if you have an alternate, a trustworthy kid or something like that is a good one to have.
Yeah, so this morning I met Ron, Barry, your financial helper. He said, Jeff, are you going to talk about powers of attorney? And he mentioned springing documents.
Yeah.
He's a financial person. Some of you might be. Wesley, you'd probably recognize too. So springing powers of attorney make you feel a little safer because that person doesn't have the authority unless I get a bump on the head. But now I got to prove you've got that bump on the head. And according to Ron, he said, they don't work, folks. I can't do anything on that day when you walk in with that springing document. It's not active right away. So his comment was, be careful on springings because it takes a little longer to actually get it activated. Does that make sense? So we just got to be careful. So if you ever see a general durable or just durable POA, power of attorney, that means it's effective immediately.
How long would that be? A year or 6 months?
So
How
it's
long would that be if there's a delay, if it's a springing? I'll let the attorneys in the room answer that. It just probably depends on how quickly.
The delay in getting the doctor's note, essentially. So you need a medical professional to sign a document, like an affidavit of incapacitation, saying that the principal, you, have a bump on your head and can't make decisions on your behalf. How long do these last? They last until you revoke them. They're durable power of attorney. They will last until you revoke them or until you pass away.
They don't expire unless you make them expire, and most don't. Most people just keep it open.
Yeah.
So that's a little bit of a difference between a springing and a durable, which is effective immediately, and then we usually do a durable. Susan, I don't know if you do the same thing, but well, I mean, we'll do whatever the client wants, but that's a little bit of the difference. Any questions about, besides this one? That was a good one. Any other questions about this financial document that we use while we're living?
All right.
All right, that's the power of attorney. So money, money, money. All right, the second living document is just a good old-fashioned healthcare directive. I got an example of a Washington one up here, and there's different versions of this you can get. Sometimes there's no universal form for a healthcare directive. In Minnesota, there's all kinds of different varieties of this document. So just find one you like. Many times a lawyer will give you a good financial power of attorney and a healthcare directive if you're getting any legal work done, but if you're just looking for this on its own, you could probably find one. Your hospital might even present to you a healthcare directive. I bet some of you in the room are from the medical industry or nurses or working in that field. You'd probably be dealing with these all the time. Doctors are always asking you, do you have a healthcare directive? So we know what to do if you get wheeled in. Otherwise, again, if there's no instructions or if there's no communication, and now, Mom, you got a bump on the head, and if Andrew and I are your sons, we don't know what to do. He thinks one thing, I think something different, and now we're fighting at a very sensitive time when we should be making a decision about you. So help your named agents help you by getting it in place, filling it out, and then we think you should have a copy on file with your doctor, and even probably give a copy to your agents, but Susan will talk to you more about that on how to manage this document. So this one's for medical wishes, where you document your medical wishes. And you can be as detailed or as general as you want. But please write something down, because when we review these documents, most of them are as blank as the day they were signed. And that's not doing anyone any good. Yet you named those people, and now they feel that responsibility, but you didn't give me any authority. Well, Mom or Dad, Barry, you didn't write anything down here. I mean, what do I do? And now we're fighting over that heavy-duty decision, and we don't want to be making a heavy-duty decision at a time of stress and emotion. So this is a good healthcare directive. Again, one of the 2 living documents all of you should have, and it's only valid while you're living. Once you move to heaven, we toss this, and then we grab the will or the trust.
Any questions on
yeah.
that?
Susan, any comments on this? Are we doing okay up here?
Doing great.
Okay.
All right.
All right. Okay, those are the
Passing
living
the
docs.
test.
Make sure you get them and fill them out. They'll come. Anyone that needs any estate planning work, again, most law firms will always include those with any type of plan they do, because they're so common and they're just so powerful. So they're important. We're going to switch gears and end up here talking about wills and trusts, because these are the biggies.
Yep.
All right, here we go. Let's talk a little bit about what a will does and what a will doesn't do.
Sure. As Jeff said a number of times, a will is a set of instructions. It, in and of itself, does not avoid probate. You need other documents to go along with your will to do that. A will names who's in charge. So one of the pieces of uncertainty is who's responsible for making decisions when Mom and Dad pass. That's called a personal representative in a will. A court will appoint a personal representative of the estate in the absence of a will. And that can cause some delays if you have more than one child and more than one of them want to be in charge. There could be disagreements about who that decision maker is. Well, what a will does is it says, I want this person to be the personal representative of my estate. So it names who's in charge. It names who receives what. And if you don't have any other documents, that's what the court will do. It'll say, okay, the house goes to my 3 kids in equal parts. It says that. I want 30% of my estate to go to my church. That's what it says. And if you have a minor child, it can name a guardian. So you can give guardianship instructions in a will as well.
Yep.
What it does not do is it doesn't convey your assets. What conveys your assets are your beneficiary designation forms, payable on death forms for your bank accounts, and transfer on death deeds for your real estate. Those are what convey the property at death. The will just gives instructions on what you want to have happen. But as we said earlier, those documents trump whatever the will says. So the will could say, I want my house to go to my 2 children 50-50. If your transfer on death deed says it's going to 1 kid, well, then just the one kid is getting the house.
That's
and
right.
it'll be up to them to decide whether or not they want to share that house with their sibling.
How many of you have heard of a transfer on death deed, and how many of you have one? I bet there's probably even a few in the room. Because with a will, that's the only way the house is going to get from A to B, right? Without probate. Without
Yeah,
probate.
without probate.
So it's such an important thing. If my will said, I want to give 30% of my estate to the church, Barry, but my beneficiaries have all the money going to my ex-spouse or my children or my brother-in-law, well, they're getting the money when I die, and there's nothing left in my probate estate to give to the church, even though you wrote it clear as day. So you see the importance of aligning the assets with the estate plan, so everything kind of goes smoothly according to your wishes. It's really important, and we see a lot of disconnect between beneficiaries and the plan.
Who has a will? Show of
I
hands.
bet there's a lot of wills in the room.
A lot of people?
Yep, most people do.
How many people have a trust?
Okay, good. That's about the proper
Usually, if you
breakdown.
have a trust, you also have a will. It's called a pour-over will. It's part of the trust. But those of you with wills, do you know that it's aligned with whatever your transfer on death deed is or your beneficiary designation forms? Yeah.
When's the last time you looked at them or maybe updated them?
Yeah.
It's
So
really important.
wills aren't bad documents. They're very, very useful documents. And with the right planning, they too can avoid probate.
Right.
But you need to have these other documents in place in order to do that, and they have to be aligned. Otherwise, it can cause some problems. Anything else?
Yeah, so that's how important beneficiaries are, okay? Transfer real estate keeps everything, a will does not keep your estate private. All of you can even go to Minnesota, look up 2013 in Wright County, Minnesota, and look up the Litvin family probate and all the fun we had, 13 months working with Ken, all right? And because everything's on the public record system.
That's a good question, though, Jeff. Are your court records online here, Susan? They are, yeah. So we have something in Minnesota called the Minnesota Court Record Online, and Washington has something similar. So if you open any kind of legal case, it's going to be on that online portal
right.
that anyone from the public can see.
Yeah. Well, my dad wouldn't like that, but he thought they had everything in order. So, and to this day, that's our family information, including a copy of Dad's will, is still on the public record system there in Wright County. So now most people aren't searching records, but guess what? Some people are, and it's usually not the good people out there trying to find names and stuff. And what a will doesn't do, I put Minnesota here, you could just swap out Washington. A will does not avoid any kind of estate tax without proper planning. So this is really important for all of you here on the West Coast when we're dealing with highly appreciated assets, good investments, right, Dennis, that have grown over the years, and we've got this taxable estate that no one's ever talked to you about because we're not always thinking about taxes. And so we want to be cognizant of that. So a will doesn't do anything really about estate taxes. You'd have to either consider a trust or do some preventive planning. Yes, sir.
Yep. Great question. So the question was, if you have a trust, why do you need a will? Because you might not have funded your trust properly. And what the pour-over will does is it can take those assets that might not either be in the trust or pointed to the trust and direct where they go. So it's kind of a catch-all to have a will inside of your trust. And when we talk about trust, we'll talk about funding the trust. This is another reason we see a lot of probates is people spend their $5,000 or whatever getting their beautiful trust set up, and then they don't put anything in it. Well, then it's a worthless document. But we'll talk about that in a
Number
second.
one problem.
Yep.
All right, so that's just a little, we're just here to learn tonight, right? So again, there's more to this than just signing a document. So nothing wrong. Yes, sir.
A question relating to the last comment. If you have a will, why do you need a trust?
Great question. The question is, if you have a will, why do you need a trust? So a will, in and of itself, doesn't avoid probate, but you can absolutely have a will, transfer on death deed, beneficiary designation forms, and everything flows just fine. You don't need to probate an estate that is set up correctly. The reason you would have a trust, and we'll talk about this a little bit more when we're going, is if you want to kind of control the distribution of the assets to your beneficiaries. If you want to have a little bit more metering of when those go, that's what a trust can do.
We're going to cover that.
If you have a sizable estate or are charitably inclined, it is easier to avoid the Washington state estate tax. And it's easier to specify which types of assets go to your charities versus your other beneficiaries. Does anybody know what the Washington state estate tax threshold is?
Wesley, you can't answer that. You're cheating because you're smart. You know this.
$3 million. It's
Yeah.
$3 million. And I believe any dollar over $3 million, Susan, is it 40% or 20%?
It's a graduated rate from 10 to 35%.
Graduated rate from 10 to 35%, depending on how much over 3 million you are. And what you can do with a trust is you can set it up in such a way to avoid that up to a higher threshold for married couples. So that's why. Yes, sir.
Well, now, if you have a will, is the $3 million limited to the total value of the estate? Or if in your will, you say, I have 10 kids, so each kid gets $300,000?
Great question. So
Why
does
don't
the
you repeat
estate
it?
tax count for the total value of the estate, or
Can
just
you-
what your...
Let's repeat that question.
Oh,
That
I'm
was a good-
sorry.
that was a
Okay,
good
so
question.
I think I was repeating it.
Oh, I'm sorry.
Yeah.
Oh.
So does the $3 million threshold count for your whole estate, or is it what the gifts are to the individuals, right? So if you have a kid that's getting
Overall.
$300,000 and you have 10 beneficiaries, they're each getting $300,000 of your $3 million, are they going to be taxed? It's your entire estate. So if your estate's $4 million and you pass out, $400,000 to each of your 10 kids, your estate's going to be taxed at $1 million. So whatever that percentage is. Is it 20 for $1 million? Do you know what the?
Sorry. So, $1 million over $3 million?
Yep, 1 million.
I'd have to look at the chart, but I think probably just 10, maybe 12%.
So 10 or 12% of that million. And it doesn't matter how many beneficiaries you're giving that to, it's your estate. And so 10 or 12% is $100,000 to $120,000 in tax that could otherwise be going to your church or your charities or your kids. But that's the answer to that
So
question.
we're going to talk more about that in a
Yeah,
second.
we
Yes,
will.
ma'am.
You were saying something about 300,000?
That was just an example.
Yeah, okay, so what I'm asking, that figure, you're saying over that, then we tax, but we don't have to tax that?
Nope, 3 million. Anything that's in your estate, including your life insurance payouts, is taxed. So anything over
Time of your death.
at the time of your death, yep, at 3 million or above.
Well, it costs money to die.
It does.
It does cost
Yeah,
money to die.
Yeah.
Yeah.
Not if you set it up right.
That's right.
That's what we're trying to avoid here.
not if
a
you,
nice cheap death. That's what we want.
Well, and taxes aren't fun, and we're not anti-tax or anything, but I'm pro. I am pro-church. I am pro-nonprofit. I'm pro-planning,
Yeah.
and so many times we can eliminate that check that we're writing to all of our daughter named Iris, as I like to joke, and then have that go to some other place that you care about. So we'll get in it. Sometimes people are choosing a trust. It's not that you need it. I don't even like using that word. I have no idea what any of you need. Only God knows what you need. But you might want to trust when you find out how they work. It's an option. And part of tonight is learning more about these options, and then you make that decision based on that. This is a lawyer in Minneapolis that explained what a will is. He says a will is nothing more than a public love letter you write to a probate judge you haven't even met. So I thought that was a cute quote, and this is from a lawyer describing a will. So again, the will doesn't convey anything initially. It's just this instructional sheet that I wrote. So don't pass away with just having a will, because we're going to have people like Susan and Andrew fix the probate assets and get things actually transferred. And that is what we're trying to avoid.
So the bottom line is wills can be useful documents as long as you have other documents supporting them. If you want to avoid probate, you can absolutely do that with a will. It's just a little bit more choreographed with your other documents.
And we're going to talk about why a will fails, and we're going to revisit what are these other documents. So you'll see what we mean in a second. So let's keep going. Now, in Minnesota, we've got a little document. You don't have this here in Washington, but We have this, it's available to every resident, they can download it, and it's even the Attorney General of Minnesota that says having a will does not avoid probate. So it's just understanding the will itself is a court document, but if you set up the assets correctly, then we can avoid probate on those assets. But you have to make sure they have a place to go once you, the owner, is gone. Now, we'll get into joint ownership and, you know, all that kind of thing here in a second. So that's just a little resource that Minnesota provides. So now, not everything does go through a will, so I know this is small print. We're probably going to update this slide, and we'll talk more about these things high level. But in Minnesota, and Susan, I don't know if you would agree, the number one issue in our state that causes probate is real estate.
Yep.
Nothing pulls your loved ones into the court process faster than real estate that was left behind, that was not set up correctly. No transfer on death deed, or no trust, no conveyance into a trust, or perhaps they put their children on the deed while mom and dad were living to try to avoid probate. Well, now we got capital gains issues that no one saw coming in the future. There's all kinds of things that we can deal with real estate. So we can talk more about how it transfers. I don't know if you want to get into this now or later, but just know that real estate's important. So those of you that have a will and you don't have a trust, you would likely consider or talk to Susan about what can I do about my real estate. I don't want to probate it. What are my options? And she'll explain some of those, but that's where we're going here.
The biggest option is the transfer on death.
That's right.
And this is something that you record against your property that conveys that property to whomever you name on the deed that it goes to.
Yeah, we'll talk about that in a second. Does that make sense? Transfers on death. You own it as long as you're living. Your loved ones won't get it until you punch your ticket and head north, all right? And but there's some pros and cons to a transfer deed, and we're going to talk about that here in a little bit. So here's another asset that you can keep out of the will and probate, your retirement and insurance. So Wallace, this is your world that you lived in, and whether we're dealing with retirement accounts, investments, stocks, bonds, non-qualified brokerage accounts, Roths, IRAs, all this stuff, all that, life insurance policies, is that not a big part of your estate? Right? These are wonderful assets you've watched grow over the years if you've saved and invested. Well, A, they're taxable, some of them, when you pull it out, and B, are they all set up with proper beneficiary designations? So when the owner dies, the company knows who to give the money to. Otherwise, the money's going nowhere, right? So that's, keep that in mind. Everything in that financial and insurance world has to be addressed. And we have seen financial advisors over the years that don't even know to add transfer on death on a brokerage account because they just don't deal with this world very often. Doesn't mean they're a bad broker, but they're managing an account that got stuck. I had one in Minnesota that had $600,000 in it. The lady passed, and it was a gift from her parents, so her husband wasn't on the brokerage account. Wesley was owned in her name only, so she passes, and her own husband couldn't get that $600,000. And the advisor was a CFP. 7 years, a certified financial planner, was managing that beautiful investment, and never once did that lady bring up transfer or TOD, which is a designation you put on your brokerage account. It's like a beneficiary. And so her husband had to probate that account. Isn't that, so it's so easy to fix. So keep this stuff in mind. We'll talk more about it as we go. And then other assets you might have. It could be bank accounts. It could be your EE bonds, or you might have precious metals. You might have other things. You might have a guitar collection for all we know. Everything's got to have a place to go. And it's your and our job working together to make sure that transfer is smooth and efficient, maybe with control and protection over the timing, privacy, probate-free. That's a good estate plan. So these are just some things that you can address where they would not go to probate, but they have to be addressed properly. Anything you want to add? Or yes, sir, over there.
Yeah, this is a community property state.
Mm-hmm.
So
Yep.
if husband and wife, husband dies, all the assets, do they not transfer to the wife in that case, or the surviving spouse? And there shouldn't be probate on that, is there?
Yeah, generally not on the first death of a marriage. First death, it's a community property state that generally transfers relatively easily.
I have a question on that. I have a
oh,
question
yeah.
too. That's a good question. So you're a community property state. Minnesota's not. We're a common law property state, so ownership can be a little different. But Susan, if there's community property that a couple acquired a home or a joint bank account, or let's just say a piece of property, community property, they got it while they were together, so it's considered to be owned by each spouse. But if one spouse dies, the surviving spouse still owns their half, but doesn't that deceased person's half have to be addressed, or is it just like joint with rights of survivorship? Doesn't it depend on the deed?
Well, so generally, there's not a probate at that first death, but it doesn't mean that, well, it depends. So if there's separate property by either spouse, and there's no, community property agreement, then the separate property can be subject to probate.
Right.
That's why oftentimes couples that have been married for a long time, will have them sign a community property agreement. So that just, everything they own, whether it's separate or not, upon death, everything goes to the spouse.
Please repeat.
Well, she gave my favorite lawyer answer,
Yeah,
and
she
that
did.
is,
Yeah.
it depends. It depends. So generally, yes, the property will transfer to your surviving spouse. But there are caveats to that, depending on the titling of the asset and other things. For example, if you inherit, you as a spouse inherit property, that's not necessarily community property. That could just be yours individually. And so if you pass away shortly after inheriting something, that your spouse, your surviving spouse, may have to probate. So there's caveats to all of that. And having a good plan eliminates those caveats so that they're not having to deal with kind of these one-off situations or exceptions to the rule. Yes, ma'am.
When my husband died, I couldn't find my will, but I did find my community property.
Good.
And it was the smoothest thing there ever was.
Yep. So you,
I didn't have to do a thing.
Well,
so you had a community property agreement with your
I
husband.
also had a will, but I found where I kept it later.
Yeah.
yeah.
Well, that's good because when your husband passed away, you didn't necessarily need your will because you had that community property agreement.
I will say that transfer of assets between spouses, folks, is about the easiest planning you're ever going to do.
Yeah.
Okay? Our job is to get the assets when both of you are gone. Where is the asset going to go then? That's really what we're talking about, because you can be community property and joint ownership all day long, but your children aren't a community owner with you, and your children are likely not a joint owner with you, and we would argue they probably shouldn't be, depending on assets. It depends on the situation. So what happens to these wonderful assets when both of the owners are gone? That's really what we're trying to focus on. But these are good, because when it's set up correctly, it is a blessing, isn't it, when we lose a spouse, so we don't even have to deal with courts and lawyers then.
Yeah.
All right, well, let's keep rolling here. We got to get some time to the trust. But we talked about the transfer on death deed. There's pros and cons to this, and Minnesota is the same way. So my mom and dad did a transfer on death deed, but Ken didn't get all of the grantees set up correctly, or actually he didn't get all the property set up correctly. These are some problems with the transfer on death deed. Good news with a transfer deed is they're cheap, they're easy to get, they transfer the real estate from A to B, and it avoids probate. Those are all good things. But some of the negative things are what you're seeing up here. In Minnesota, most of the time, as I've heard Andrew say, technically, the children only need to sign on that deed when they want to sell it. So when me and my 3 siblings inherited our parents' property, even after it went through probate, we were all co-owners of it. We were tenants in common. Well, we wanted to sell it, and I already had my divorce in 2009 that I did not want and did not see coming. That's another thing we always don't think is going to happen. But my other siblings were married, so how many signatures did we need to actually sell that property? We needed 7. So multiple signatures can sometimes be an issue. The grantee judgments, as I've heard you say, if one of us 4 kids was going through a legal issue, if someone was suing us because maybe we were in a little accident or something and I had this judgment against me, here comes the property that I can't stop, and that judgment would have just attached to my ownership
That's a good
share.
question. Susan, are you guys a Torrens state? Do you have Torrens titling out here? Or is it all abstract?
I don't know the answer to that question.
Do you know the answer? very rare.
Yeah.
So, what is it? Good question. So, property can be titled two different ways. One is Torrens, which is registered, and one is abstract. So, when you bought your property, you might have gotten an abstract, which is a big book of all the ownership and lien history of the property that you own. That's called an abstract book. Most property in the state of Washington is abstract. And when you get a judgment, or if a person has a judgment against you in the county in which that real property exists, it automatically attaches to that property. With Torrens, it's different. Torrens is registered. Things have to be filed. It's a one-page, it's a cleaner document.
Yeah. It could expose that ownership of the
Yeah.
property to your legal issue is what we're talking about. Because
Yeah.
the child, the grantee, cannot control. They're just going to get that ownership, the day after mom and dad pass. Transfers on death, right in the middle of a divorce or a lawsuit. And then don't forget about insurance, because in Minnesota now, there's 3 steps people need to go through when they have a transfer deed. We have to notify our insurance company as well, because the ownership's going to change at some point in the future, and you're the homeowner. You're the one that has the insurance policy, right? Your kids aren't on that policy. So there could be and have been issues, even in Minnesota. There was even a national case where the young gal received the house on a transfer deed, and by the time she sold it, it had burned. There was a fire, and she lost the house. But she was the owner according to the deed, but no one notified the insurance company that the ownership changed, and the insurance company won that lawsuit. And that set up a precedent to change how we approach insurance companies and notify them. So there's some pros and cons to a transfer deed, so just be aware of that. The biggest one I don't like is kids have no idea when you're going to move to heaven, and they have no idea when they're going to wake up and they're going to be the co-owner of a home. And you're forcing all the kids in ownership together. I'm all joined at the hip now with loser Larry and my good brother Andrew, and I've got a controlling sister Carrie over here, and we all got to work together now. And that may or may not go very well. And then we all need multiple signatures and things like that. So just be careful.
Right.
You can discuss this more with Susan down the road. They work well to avoid probate, but they don't work well if you're trying to give it to 5 or 6 kids and they're all married. Right?
So generally what we like to recommend is if you have 2 kids and maybe they're married, maybe they're not, transfer on death deeds are generally pretty efficient. You start having 3 kids, 4 kids, 5 kids, and they're married, it can get really, really, really tricky for those kids to sell that property. Because if there's a disagreement on what to do with it, if one of them wants to keep it, if one of them wants to move into it, one of them wants to rent it, 2 of them want to sell it, well, who wins? Nobody does. So they have to go to court to figure out what to do with that property. And so the more people you put in charge of making that decisions, the more of a mess it can become.
It could.
And so transfer on death deeds are great. They're an efficient way to convey property at death, but they can lead to some problems down the road.
Yes, and that house is going to transfer outside of your probate estate, outside of the will.
Correct.
So if your will says, I want to give 30% to my church when I'm gone, well, you just sent one of your primary assets out the side door directly to the children. They own it. That's not being considered in your estate plan. See how there can be a disconnect between assets and your written instructions. Let's keep rolling just for the sake. Here's some reasons why wills might fail. Why don't you take this one?
Before we move on, does anybody have any questions on transfer on death deeds?
What, on a Torrens, how do you spell that?
Torrens. Yep.
Okay, and so that's, how much is that? I mean, what are we talking about financially?
How much is No, it's nothing to do financially. Your property, you can register your land, but nobody ever does. It either is or it isn't. So either your property is going to be titled as Torrens or it's going to be abstract. There is a very kind of lengthy process you can go to register it and make it Torrens, but we would not recommend doing that.
So I just crossed that off.
Yeah, cross that off your list. Yeah.
Your plan just got easier.
Yeah,
right now,
yeah,
so
easier.
Love that.
Yep. Anybody else? Transfer on death deeds. Okay. Why wills fail? Mainly because people think that they don't need to do anything else but the will. So they have a will, but they don't have a transfer on death deed. Well, that property, if you own property, that's going to have to be probated, regardless of you having a will. They fail if your will doesn't align with how your beneficiary designation forms are. If you're charitably inclined or you want a distribution scheme that's different than what's on your will or what's on your beneficiary designation forms, that can cause a lot of friction amongst the beneficiaries, and it leaves a lot of decision-making for the people that actually got the property to split it up how you have it in your will. They don't have to, because that passes outside of your estate. They fail because we don't communicate. So we've seen this a lot on the probate side of the fence. I know mom and dad had a will, but we don't know where it is. Well, if we don't have the will, guess where we're going? Probate. And then there's no backup name. So if you have an older will, and maybe this was when your kids were minors, and you named your brother or your uncle as your personal representative, and that person has passed away, well, if you die, then the court is going to have to decide who the new PR is going to be. And so that's one of the things that's important about updating these documents, is making sure the people that you've named in various positions are willing and able and alive to be able to do it. So we see several different instances as we're helping people on the probate side of things whose parents had wills, but they just fall apart because there's no alignment, there hasn't been any communication, or the nominees have passed away.
Yeah. So one of our goals tonight is just to help you understand you might need to do a little bit more than just get that will in place. And if you're good with that, if you got that seared to memory, we're in pretty good shape. The last thing I'll say on wills before we move forward is if you've got transfer deeds in place, if you've got beneficiaries all set up on every asset, okay, transfer on death on your brokerage account, payable on death on your bank accounts, okay, do you know you can add a beneficiary on your checking account? And yep, you should. These are all beneficiaries. So if that's all in place, the good news is the kids are going to get the money when you're gone, right? And no probate. Did you know that sometimes the bad news is the kids are going to get the money when you're gone? No control, right? No warning. No idea you were going to pass away the other day. Here comes all the money in my life. I'm right in the middle of a divorce I never saw coming. I got this issue I'm dealing with. Maybe I was incapacitated due to an injury. God forbid I develop special needs, or I'm gone as your son, and now my share is going down to my kids, but the beneficiary form you use doesn't do that. Things can get stuck, and things can transfer into children's lives when they're not ready for it. So that's why sometimes people would like to control that distribution a little bit better and give the kids more of an ability to take a breath and kind of manage their own inheritance, and that's what a trust can provide, and we're going to talk about that next.
So on that transfer of death, if it's equities or insurance policies or property, somebody's going to pay tax on that. How does that, in this state, at $3 million, that starts to escalate the estate? If that transfers of death, do your kids pay that tax, or does the estate pay that tax, or does that tax get lessened because into the estate so there's less tax?
Well, in my opinion, we're talking about two different taxes. He asked about when the property transfers, what kind of tax is paid. There could be a capital gains tax, but normally there isn't if it's done correctly. But if your estate's over $3 million, we have to take a look at that overall estate tax.
Estate tax, yeah.
That would be the tax that would be paid, am I correct? Not really a tax on the property itself. There's
So,
no
yeah.
capital gains.
The estate would pay the tax, so it would come out of whatever the estate is.
So it is the tax of the estate, not a capital gains tax.
Correct.
Correct.
The only time, maybe I should ask Susan, you get a step up in cost basis on inherited assets here? So if you inherit a piece of real estate, the cost basis, the amount that your beneficiary acquires the property for, will be the value of the property the day that you die. And so when they sell it, if they sell it for that amount, there's no tax to them. Same with cash that they receive, things like that. If they receive IRA or 401k or 403b money, there's a rule that they have to withdraw that money over a 10-year period, and they will be taxed at their income tax rate on those withdrawals. And so there's a little bit of income tax on it, but the big tax that we're trying to avoid is the estate tax. Yeah.
Yep.
Does that answer that question? Yeah.
All right, let's keep rolling. So let's talk about a trust. A trust, folks, is just another option. Some of you have one, and let's talk about that a little bit. You know, we say here a will describes your intentions. A will is just a set of instructions, but a trust can actually execute them, because a trust is, I don't know why we use the word execute when we're talking about estate planning, but maybe that's not the greatest choice of words here, but a trust will actually activate them and carry them out. So a trust, as you probably know, is an entity that you create. A will is not an entity. A will is just a set of
Oh, go back one slide.
Oh,
Sure.
I'm sorry. Let me get back here.
There you go.
There you go.
Yeah.
Yep, you can take pictures of anything. And by the way, we're going to, Barry, if anyone needs a copy of the slides, Chris and I are working on that. We're happy to leave that behind. We just want you to use it for your own internal learning and just don't throw it out online. So this is just a little high-level description between the two. Let's talk a little more about them, because there's more to a trust than even getting that signed. But a trust, generally speaking, provides these adjectives better than a will does. A trust can control the flow of assets better. It's usually more efficient because one person's doing all the work and not everyone is involved, including spouses. So we minimize the number of people that are having to deal with death certificates and make phone calls or filling out claim forms. A trust is completely private, unlike a will, and we think it does offer a greater degree of protection over the assets and over the children. So for example, you could do a transfer on death deed. I've got 3 kids back in Minnesota, 1 girl, 2 boys. 2 of my kids are married. I could do a transfer deed on my home to my 3 kids, and they will get the home when I'm gone, but when they want to sell it, we need 5 signatures, right? My 3 kids and the 2 spouses. And they don't know when they're going to wake up and own the home, in case one of them might be an issue. So I don't want to do that. So instead, I put my house in my trust. I retitled it, just used a deed, quitclaim deed or a warranty deed, whatever Susan would recommend. And now my trust, my 3-ring binder, is the owner of my house, right? And now when I'm gone, only Hannah, my daughter, who's my successor trustee, she's the only one that needs to be involved to sell my house out of the trust, get it sold, and we don't need the 2 boys, her brothers, and we certainly don't need their spouses. Well, that's control, is it not? That's protection. This is just an example of what a trust could do. So these are some reasons why people appreciate a trust. You might see yourself dealing with some of these unique circumstances, and a trust can do better with this. You know, if someone is dealing with special needs in your life, they likely should not be named on a direct beneficiary, because that money would go directly to them and it would mess up their government assistance if they're getting any at the time. Whereas you could have that money routed to a child's trust, and then they could be supplemented out of that trust and kind of fill in the gaps and get the best of both worlds. So these are just a bunch of different examples. We don't have to go through every one, but that's what a trust does. It can hold and protect assets for the benefit of others. And this is where you can do a better job with your charitable giving. You can say, when I'm gone, I want 10, 20, 30% to go to my church. My children will get the remainder. And and so you write that in the trust, and we're going to work with you, and so will Susan, to get all your animals inside this fence, right? We got to retitle the assets. We got to fund the assets into the trust. That just means retitle them. Change the beneficiaries. And name the trust now as the beneficiary, so all the money's coming to the rule book when I'm gone. Does that make sense? And then Hannah's in charge of my rule book, but Hannah can't change my trust when I'm gone. It turns irrevocable upon my death. It's revocable while I'm living. You can change your trust. It's your rule book. Update the rules, kick someone out, disinherit Larry, give more to church, whatever you want to do. And then when you're gone, it turns irrevocable. Now Hannah's in charge of a document she can't amend. And it's a nicer way of locking in my wishes, and all the assets are in here, so she'll be able to liquidate them and then distribute those assets according to my wishes. So one person's doing all of that. And the last thing I'll say, let's say my youngest son, Aiden, is not doing well at that time. God forbid he's going through a divorce or something, or whatever, creditor. He would have an ability to kind of manage his own inheritance. He could say, Hannah, I don't want my money from the sale of the house. Can you leave it in trust? I'm dealing with something in my life. I don't want that money hitting my balance sheet and going in one hand and right out the other. Yeah. Can I leave my inheritance in the trust? And then I'll come back later when the coast is clear, and then I'll take it. And she can say, yep, I can do that for you, and I'll leave it in here. So there's just some examples of what a trust can do.
Another thing a trust can do is it can meter the inheritance. So let's say you might have a child that's struggling with addiction, or they're struggling with gambling or whatever. You can set up a subtrust for them within your trust that says this inheritance is going to pay out X amount per year over whatever period of years you feel comfortable with. So it gives you just another element of control to be able to meter those out. A lot of times we work with younger parents who might have an 18 or a 19 or a 20-year-old kid, and maybe they don't want a 20 or a 21-year-old to get $500,000 at that age. That might not be the best thing for them at that time. And so they can say, you know, I'm gonna set aside this money for them, and they can use it for school, they can use it for health care, they can use it for purchasing a home, but the rest of it is gonna stay in this trust, and then they're gonna get it when they're 30. They're not gonna get it right away. So
Or
you can
whatever
set your
age.
trust up to distribute however you see fit, to determining what your kids or your beneficiaries' circumstances are. I feel like it's a little bit easier too with beneficiary designation forms to just point them to the trust. Then
Yeah,
you don't
that's a
have to
good point.
update them very much when you change.
Yeah.
You just have to update the trust if you want to make a change.
Yeah, that's a good point. My 3 kids are not named on any beneficiary of any financial asset I have. My trust is named as the beneficiary, and I never got remarried after my divorce, so I don't have a spouse. Normally I'd name my spouse first, right? But I don't have that, but instead of naming my kids directly, I'm naming the Litvin Family Trust. And all the money's coming in one bucket. Let's start with you, sir. Go ahead.
Yeah. Could you explain again revocable versus irrevocable?
Sure.
trust?
So the question is, what's the difference between a revocable and an irrevocable trust? Revocable just means you can change it. So it's a revocable trust. You can get rid of the trust. You can change it. You can name a different trustee. You can retitle assets in it, whatever. Irrevocable is the opposite. You can't change it. And generally speaking, once you pass away, you're the grantor of the trust. Once you pass away, your revocable living trust now becomes irrevocable. So your successor trustee cannot make changes to it. So revocable, you can make changes to it while you're alive. You can update it, amend it, do whatever you need to do. Once you pass away, it becomes irrevocable, and your successor trustee cannot change it after that. Sometimes people will set up an irrevocable trust while they're alive, and they'll do that for charitable reasons or Medicaid asset protection reasons or various tax strategies. So that's a little outside of the wheelhouse of this conversation, but that's the gist is revocable means changeable and revocable. Irrevocable means unchangeable and not revocable.
Yes, ma'am.
Also, there's a living trust, is that different than
Nope, that's the same thing. So we're talking about a revocable living trust.
Yep.
Yep.
Living means you set it up while you're alive versus a testamentary trust, which is created for you after you're gone, and some wills do that.
How do you know that you're looking at the latest will or the latest trust?
It's a good question. So the question was, how do you know that you're looking at the most recent will?
Andrew, can you
or
repeat the question?
I am
No, just
repeating
kidding.
it.
Just making sure.
How do you know if you're looking at the most recent trust or the most recent will? Now I'm going to turn red. Thanks, man.
No, that was self-depreciating humor on my part, not you.
Yeah, I
You're doing
appreciate
great.
it. I appreciate it. Generally speaking, it'll say this document revokes all prior documents, and it's dated. And so you won't know that it's the most recent other than there's no other document that's dated more recently than the one that you have.
So do they all go to one repository or they all?
Great question. Where does it live? Where does your trust or your will exist? Well, if you have an attorney draft one for you, your attorney will have a copy of it. You'll have a copy of it. And what we recommend is you give the person that you're naming as your successor trustee or your personal representative, you give them a copy of it. So I would argue that you would want to put it in 3 different places. Leave a copy with your attorney, put a copy in your safe, and give a copy to your personal representative or your successor trustee.
We even digitize it as well, so you can
Yeah.
have a digital copy, and sometimes that's nice to work with. But you'll have the original, at least that's what we do. We have you take the original home. It's your estate plan. We've got a backup for you in case it gets lost in a fire or something like that.
Yep.
But there's nothing wrong with keeping it right at home. Safe deposit boxes are actually a little bit difficult to get into once you're gone, so be aware of that.
Also, I just
Good question.
Yeah.
So the question is it a good idea to put your retirement accounts into the trust? So you can't actually put them into a trust.
Correct.
You can name the trust as a beneficiary of those retirement accounts, but unlike all your other accounts, you can't put those into your trust right away. Those are your personal things. The reason why we like to point the IRAs or the 401ks or the 403bs to the trust to control the distribution. The reason why some lawyers argue against that or some financial advisors argue against that is because if the trust has to start pulling the money out, there's an accelerated tax on it. And so the tax implications of that could be higher than what a normal beneficiary would get. And so that nuance will come into play as you're kind of tailoring your estate plan to what your assets are or where those assets are going.
Yeah.
For example, we have somebody that we're working with right now that's setting up a special needs trust for one of their children. So they have 3 children, 2 of them are inheriting outright, 1 of them is inheriting through a special needs trust. Now, we had to set their asset buckets up a little differently so that the retirement money was not going into the special needs trust because the tax on that money as the trust is withdrawing it would be very, very, very high relative to what the other children would pay over their 10-year period. So that's why it's important. That comment right there is why it's important that you have these conversations with your lawyer, your finance professional, and your tax accountants to make sure that whatever it is you are setting up makes the most sense and is the most efficient tax-wise for your beneficiaries and for your estate overall. So great question.
Yeah, we take it a step further too when it comes to charitable giving. We'll talk about it in a second to make sure if you're doing any charitable giving in the future that your successor trustee, who's kind of like your executor, takes that gift of money out of the right bucket at the time. So we'd want to make sure we're looking at what assets are taxable that I'm leaving behind. I want to give to the church, Barry, out of my taxable bucket. Bless the church, don't pay a dime in taxes, and now I've reduced the remaining taxable estate for my family that'll have to deal with it.
Just a quick question, because I actually have a friend who's going through this. So right now, your trust is going to your 3 children after that, or how you said that.
Yep.
But if you decide to get married again in a common law state, does she own part of that trust?
Good question. She would not automatically, if I get remarried, what happens to my common law trust? If I've got one now, which I do, it's in my name only, and it's not a joint revocable trust like sometimes we will do. The couple in the back, you have his trust and her trust. That sounds like you did like an AB. So no, she doesn't automatically come in, but I'd likely update stuff if I wanted to include her. We'd have to just address that. But she doesn't automatically, because it'd have to be updated. There's no, because of that common law, I'd have to bring her into it legally.
Yeah.
So let's say let's say you're 96 years old,
Mm-hmm.
and she comes in and you give her all of it. Now your kids get nothing.
Correct.
Well, there you go. So
Yeah,
hopefully,
correct.
I dealt with a couple in Minnesota. I didn't 4 years ago. They just got married. He was 94 and she was 88, and they met at church, and they just got married. And we were dealing with updating their estate docs for this very reason.
So did he, in this situation that you're talking about, did he retitle everything to go to his new wife, or did he update his trust to point to the?
Well, he's dating someone. I think that's her intention. And
Yeah.
he hasn't done anything.
Yeah.
Well, yeah.
Yeah.
Well, you're right. So,
And the reality is, it's his stuff. He can do whatever he wants with it. Now, she could maybe make a case for undue influence or something like that after the fact. But if he amends his trust to point to his new girlfriend or his new spouse or whatever,
I think his daughter's going to be out of this. Is what
well, yeah.
trust should be put together to make sure that.
he can do that,
Yeah.
but she can't.
She can't amend his.
They're not in common law. They're in whatever we are. Common
Okay.
Yeah. Community property.
community property, sorry. So
Yeah.
he didn't do it before they started dating.
No, I think it's just before you start married. But this is a great question for the resident attorney when you set up an appointment with her on a nuanced situation that might be an exception to a rule. I suspect he can set up a revocable living trust and transfer his assets into that, and then the trust owns the assets, not him. And so
Well-
I don't know if that would, prevent her ownership or her spousal interest in the property later on, but that's a good question for Susan at that A meeting. Yes, ma'am?
One quick question. The 3 children, one is special needs. Why is the special needs one different than the other 2?
Good question. So why would a special needs child be different than the other children? Generally speaking, the special needs child might be receiving some aid from the state or from the government.
why.
And if they inherit a bunch of money, they might not qualify for that anymore because now they have all this money. And so you want to set up what's called a special needs trust to kind of supplement the aid that they're getting without disqualifying them for that aid. Another circumstance is even if they're not on a benefit, they might be not the most responsible child, and so you may want to dole it out in a more metered way. So even if they're not on any kind of benefits program, you might feel that it's in their best interest to receive that money over a longer period of time in increments versus all at once, because they might not be dealing with that.
So that's kind of how they work. They're an entity that can hold and protect and meter things out, but it can't protect something it doesn't have.
Yep.
It can't distribute something it doesn't have. So again, why trusts fail? The number one reason is people don't fund the trust. Susan, I'm guessing you would agree that we got this beautiful fence that we built that the lawyer helped me draft. All my control and my wishes are documented in this 3-ring binder. So I built my fence, but all my animals are running free in the pasture. Over here running free as a wind. They're not under its control. Well, they're outside the fence, and now I got a fancy set of instructions, probably doing nothing. So even with a trust, the trust can give it to his new spouse, the trust can do anything, it can say whatever, but unless we get the animals inside the fence, what is this doing? So that's the problem with trust. And then sometimes we have a deceased contingent trustee. You never had a backup plan for that. But the number one issue in our opinion is people don't retitle their real estate. They don't update their beneficiary designations. They got things pointing all over the place. Nothing's coming to ground zero. And then we get problems with the way you wanted things to play out.
So, sir, earlier you asked about why you would need a will. This is why. That will then, that pour-over will within your trust, then would come into play as an instruction sheet to a court that says, put everything into my trust. You'd have to probate it, but you could eventually move those animals into the fence with that will. And so that's what the pour-over will is for. It's a catch-all if you're not properly funding your trust.
Yeah.
And we see this a lot on the probate side. People say, Mom and Dad had a trust, it says XYZ, and their house is titled in their name. Well, guess what? We're probating the house because it wasn't put into the trust.
That's right. So here's our little visual. There's your fence, and there's our little animals. Okay, we got to get them all inside the fence so they are protected. And this could be your bank account, that could be your cabin, that could be a brokerage account, that, whatever. We have to be very purposeful on addressing the assets. So we always got to look at the assets, no matter whether you do a will or even a trust. The assets have to be addressed. There has to be alignment between them and the document, and that's where we find the ball getting dropped. So our team is taking this approach that we will not only build the fence, but we're going to help you get your animals inside of it. We're very detailed and careful in working with you, and Susan as well, on the funding, because this cannot protect something it doesn't have. And that's the biggest problem with trust. So we're going to make sure, you get your goats, cows, and chickens in there, and then you'll be good. They're still your goats, cows, and chickens. For as long as you live, you can sell them, barbecue them, breed them, mate them, do whatever you want. They're your assets. This is just to protect them all from when you move to heaven. Yes, sir, in the back.
So we have property in 2 different states.
Mm.
Can you put the trust in a more tax favorable state, or do you have to put it in your primary state?
Good question. So the question is if you own property in 2 different states, can you set up your trust in the more tax favorable state? And the answer is no. You have to do it in the state that you live in, right? And so you can't just buy a property in Iowa with no estate tax and say, oh, that's where I am. So I think, states that are less tax friendly, like Minnesota, like Washington, California, things like that, they're watching. So they're going to look at what state you domicile in, where you vote, where your
where you
primary
reside.
residence is. That's what's going to come into play with your estate tax. Yes, sir.
I'm just going into detail, I'm sorry.
Yeah.
We want to split our time in retirement.
Yeah.
Should we spend like one extra day in the more tax favorable state?
So the question is how do we get domicile in a tax favorable state? Washington will have a rule. Minnesota's, I think it's like 6 months and a week or 6 months and 10 days. So Washington will have a rule that says you can't be in this state for more than 5 months, 5.5 months or something like that. And if you are, you're considered domiciled in the state. I don't know what that is. Do you know what it is, Susan? Yeah. Yep.
Yep.
Yeah. So we have a lot of people that snowbird to Florida. Florida is a very tax favorable state for retirees. And the people that we work with have to be very careful about how much time they're spending in Minnesota versus how much time they're spending in Florida, because guess what? The Minnesota Department of Revenue is paying attention. And if they're not paying Minnesota income tax or they're trying to avoid Minnesota estate tax, you're going to have to prove that to the state that you're not domiciled in for tax purposes. So that's a nuance. If that's a strategy, that is something that you want to work closely with your tax person and your attorney when you set these documents up. But
There
great question.
are some creative things you can do. Whether it's, I guess, legal or not, it's a good question.
It's legal if you do it right.
There's some options. Again, that's where the follow-ups can have. Let's keep going. We're going to wrap it up here with some charitable giving thoughts. So the comment here is a lot of people, until they sit down and go through this, they don't really add up everything. They don't really know what they have. And I'll just ask anyone, you're closest, so I'm going to pick on you. Think of your house. How many light bulbs do you think you have in your house? Don't overthink it. Just give me 25. Most women, we ask that question, say between 20 and 30 every time. I don't know what it is, between 20 and 30.
Hundreds of these workshops.
Yeah, it's
hundreds. Always between 20 and 30.
It's either 20, 25, or 30. But anyways, the point is, if you were to stop and think of your home, you probably got 5 or 6 lights even outside the front door in your soffit or above the garage. You walk in, there's your chandelier, there's 10 more. Lights on the stairs, lights in the microwave, lights in the dryer, lights in the kitchen. Most houses have anywhere from 80 to 100 light bulbs in the average home. And we're bringing up this silly little metaphor or example to say, you know what, your assets are very similar. Most people don't add up everything because they're almost either afraid that they don't have enough, or they just assume they don't, and then they got more than they think. And if we have more than we think, now we're dealing with some taxes that we never saw coming, and we don't want to be dealing with this at the impromptu time. We want to be planning on this. So the taxes, it's mainly estate taxes, because you and us in Minnesota share that estate tax, capital gains taxes if we're not passing real estate and stock correctly, and then income taxes from qualified investments like an IRA or a 401k. They're all taxable to the kids. And folks, the tax that your kids are paying on your IRAs is based on their age, their income, and their tax bracket at the time, not yours. So if you're in a lower tax bracket than your children, who many times are in their peak earning years when we go meet Jesus, why are we leaving all this taxable money behind only to be paid at a higher rate? Who wins in that situation? Your daughter Iris, and then the Washington Department of Revenue. So let's think about some of that. So these are just a couple examples. Susan's team, our team, is very comfortable explaining if you're dealing with things like an IRA. Some of you are already probably doing this, a qualified charitable distribution. Give to the church right out of the IRA. You have to take that RMD each year. What are you going to do with it? Many people don't need it. They don't want it, but I have to take it. Well, then I'm going to give that to the church or plant a church or give it to missions. So a QCD is a wonderful option on dealing with IRAs. What if you have an appreciated asset, such as stock or real estate? Many times we consider a donor advised fund as a really cool option for you. There's a double tax benefit to opening up a DAF and utilizing that. We can talk about that more. And then large gifts for, again, some people have apartment buildings or farms in Minnesota. We got a lot of family farms that have appreciated, and they're sitting on a huge capital gain, and they might want to do something with that property or that asset. And that's where we can talk more about some of these really cool tax-friendly strategies, such as a charitable remainder trust, wonderful way to bless a church or a charity in the future with that highly appreciated asset. So these are just some options. Be aware of that. We're thinking about taxes as part of the estate plan. Anything you want to add to that?
Yeah, and I think the light bulb point is when we sit down with you and we kind of go through what you have and where you want to point it or whatever, you'll find that there is a sufficient amount to both bless your children greatly with whatever gift you're leaving them, but also leave a little something to your charity of choice or your church. And so if your estate's $500,000 or $1 million or whatever it is, and you've got 2 or 3 kids, are they going to be just as well off getting 90% of that as they are as 100? Probably, right? And so maybe 10, 15% can go to a charity or a church as you're thinking through what to leave behind and to whom. I think that's
You
kind
don't
of the
have
point.
to. Obviously, it's your money, and no one's pushing
Right.
but these are just questions we ask because we're all charitably inclined. We're all believers. We've been given all our life. I get all that. But you have such an amazing opportunity to bless, these nonprofits and use some of that money for kingdom purposes. And
Yep.
and it's so fun to give away taxable money to do that.
Right, and
so-
that's the other point is if we plan correctly, whatever you are giving to church or charity, we can do it with the most tax destructive assets, right? So you're not you're shrinking your overall taxable estate, and your other beneficiaries are getting assets that aren't as heavily taxed, whereas the charities and churches that aren't paying tax, aren't paying tax. So
right.
a good
So anyway.
plan will allow for that.
Yeah. All right. Well, that's pretty much it. So we're going to kind of wrap it up. The step 2 is really up to all of you folks. So again, this was education tonight. We're here because of Converge and the grant covering this to bring this program to you. And I hope you were blessed by the information. If you wanted to take it further, if you wanted to have a cup of coffee with Susan and her team, because she's local, we found a competent team now. We're going to be kind of there, join at the hip, working, but she would be your boots on the ground here in Washington. That's what that yellow card is for. And she even has specific dates and times in the back if you wanted to keep your momentum. And we think there's something important about keeping that momentum. Corresponding faith without works is what. So take that next step and learn a little bit. It's complimentary. There's not going to be any rug pulling or solicitation. And if you want help, just ask. She's very competent. We're the same way. We just want you to learn. And this is an opportunity to be one-on-one with her. You can do virtual meetings. You could do it in person if you wanted. But that's what the yellow card is for. And my little white tray broke on the way here. It cracked on the back side. But it's still good enough to drop that yellow card in the back tray. And there are some Post-its
One
if you'd
thing
like to
before
do
we
it.
take questions, though, is you'll find Post-its in the back with dates and times on them. If one of those dates and times work for you, pick up that Post-it and put it on your yellow card and drop it into the tray. If one of those times doesn't work for you, just write "call me," and somebody from the team will give you a call and schedule a time that does work for you. So the Post-its are set-aside times that you can just pick. If none of those work, write "call me," and we'll figure it out after the
Very
fact.
good. Yes,
Yes,
sir.
sir.
What's the time limitation on making a decision? Can I think about this for a week and then?
Oh, yeah. Jeff,
For
what's
sure.
the time
Yeah.
limitation? There is none. We want
No.
you to be ready. We're
Do
not
it
going
before you
anywhere.
die.
Yeah, just don't do any skydiving between when you leave here and when you make your decision. But no, we've had people call us even a year or so later.
Yeah.
We want you to be ready, but folks, we do want you to keep your momentum.
One of the things we hear often when we meet with people
Yeah.
is we've been thinking about this for 15, 20 years,
Yeah.
and the time to do it is now. I mean, you got the education; it's fresh in your head. Keep the momentum. If you don't have anything in place, start doing it. It's
And
time.
just know we'll work with your existing advisors and people. We want to connect those dots and make sure those plans are done properly. So
Right.
Susan and her team are well equipped like us to kind of go beyond what normal lawyers would do, because normally just stop at that legal line in the sand. But this involves a little bit more, and that's the way we've structured it from day one. That's why Converge likes this approach. So anyways, that's available to you. Again, that's part of the give. The grant is covering that cost, really. So you can go speak with Susan and not worry about anything. There's no obligation. Just know what's available to you, folks, all right? So that's what it is. And with that, unless, Barry, anything you wanted to mention, or we okay wrapping her up? Oh, yeah.
Do you have anything else that you are going to do? No,
we'll stay around for questions, obviously, and as we pack up, and
We'll
we
be
get over.
around for a while for questions. We can answer questions from here. Otherwise, we'll be in the back if you have anything specific you want to talk about.
No, but I
Great.
just want to
So-
thank you again for bringing us out.
privilege. So at 7:45, I know some of you need to run. It's past your bedtime. But again, rather than prolong things with questions publicly now, if you have questions, the team will be available for you to be able to do that. Would you join me in thanking these folks for coming all the way out here to do this? Thank you so much.
Thank you.
guys.
Thank you.
Barb, thank you. Wick, wherever you are, thank you. Yeah, appreciate it.
All right,
Have a good
night, folks.
evening, everybody.